You've been sounding the alarm about a Washington State Supreme Court ruling last October called the Hirst decision. Can you tell us your concerns?
Well, this started, as you said, last October when Whatcom County was determined to be failing to comply with the Growth Management Act and protecting in-stream flows because of their exempt well permits. That said, the court decided in that case that counties could no longer depend on the state, being the Department of Ecology, to determine water availability for landowners. Under the Growth Management Act, counties can't issue a building permit until a landowner actually can prove water availability. So it falls on the counties, and the counties believe that falls on the landowner because it's very, very expensive to prove water availability outside of DOE. That means basically landowners have to conduct what they call a hydrological study on their property, and this can cost tens of thousands of dollars, which is cost prohibitive for most landowners. So that's kind of the crux of it.
So does this effectively shut down development? And if so, what are the consequences?
Well, it does. As I say, it's cost prohibitive. Some counties have actually put moratoriums on at this point because, you know, it's expensive to do. And if you can't drill a well, you can't build a house. If you control the water, you control the land. So it diminishes the value of the property as well.
What is the legislature doing to address this problem?
Well, at the beginning of the session, there were probably close to a dozen bills to address the issue. There's one remaining. It's Senate Bill 5239. It's Senator Judy Warnick's bill, what we think will be the fix. And it basically rolls back the situation to as it was before the court decision, so we could then rely on the Department of Ecology. The implications of this are beyond just rural landowners, and I think I dropped the House Bill 2195, which would have required assessors to go out immediately or within the next year to do assessment on rural property owners, because they shouldn't have to pay higher taxes when their land has diminished value. The other part of it was to highlight the fact that this is going to create a tremendous tax shift. People need to understand the way the county property tax works. The county's still going to collect the same amount of money, but if there's such diminished value in the rural areas, that's going to create a tax shift to the urban areas. This is not just a rural landowner problem. This is a problem for all property owners, and people in parts of the state are recognizing their tax bill from the implications of ST3, you know, higher car fees, property taxes, and now higher sales taxes. This will be yet a higher fee on their property tax because it's going to create a tax shift. In Skagit County, we had a similar case on the Swinomish tribe litigated. Skagit County reevaluated 785 properties, and they found a $22 million, just slightly over $22 million tax shift. Whatcom County's assessor just recently went out and did the same kind of evaluation on properties affected by Hirst, and they're looking at a $271 million tax shift. That's going to go to the people that live in Bellingham and other urban areas and other property owners in Whatcom County. That'll be the case in virtually every county across the state.
The legislative session has only a few days left. What's being done to move this bill out of committee?
Well, we tried to get the bill out of committee. The chair failed to get it out of committee. He couldn't even get a title-only bill out of committee. I tried to put an amendment on the operating budget, and the Democrats scoped that amendment as well. So there are some negotiations going on at this point. But the other side has offered a so-called solution that includes significant fees for people to be able to drill a well. For just to water for your house, it'd be something like $1,750. To have a small garden, it'd be $2,500. To water up to a half acres, it's $7,500 to put a well in. And then they talk about mandating meters on wells and just administrative paperwork. And that's a non-starter for a lot of us. The fact of the matter is, and I think people need to remember this, that even Department of Ecology will tell you that the cumulative impact of all the exempt wells that are out there, the kinds of wells we're talking about, the water, the consumptive use of water for human consumption is less than 1% of all the water. So you have to ask yourself, is this really about the water? Is this really about the fish? Or is it more about controlling people and land use?
What can concerned citizens do to get this issue fixed?
Well, they need to light up the phones. We have a legislative hotline, 1-800-562-6000. You can leave a message for your legislators. You can leave a message for the governor. Because if we get a bill passed, the governor needs to sign it. So people need to get on the phone and light it up because they will be affected. And I just want to add one thing, John, and that is the fact that it isn't just people who own land, because if taxes go up, people who rent you're going to see their rents go up as well. This affects everybody in the state. We need to get this fixed.